There is a ledger in the records room of the United States District Court for the Southern District of Ohio, filed under the designation Marshall's Accounts Rendered, fiscal years 1884 through 1889. The ledger is cloth-bound, the cover a faded blue that has gone nearly gray at the corners. Its pages record in the careful columns of a government clerk every dollar disbursed by the Federal Marshal's Office for the custody, transport, and maintenance of persons convicted under federal law. Line items run for 40 pages. Payments to county sheriffs for boarding fees, charges for the hire of wagons. A recurring notation appearing across nearly every fiscal quarter reads per diem, state institution per contract. The contracts themselves are not in the ledger. They are not in any file associated with the ledger. The clerk who maintained it either did not have them or did not consider them worth preserving alongside the figures they governed. That absence is the subject of this record. For 102 years, from the ratification of the Constitution in 1789 to the passage of the Three Prisons Act in 1891, the federal government of the United States operated without a single federal penitentiary. A government that collected taxes, fought wars, administered territories, and maintained a standing army had made no formal provision for the long-term imprisonment of those convicted in its own courts. If this history is something you need in your life, subscribe now and hit the bell. Every week this channel follows the record into the places the official timeline would rather not illuminate. Subscribe before the algorithm decides this content is too specific. The void this arrangement created was not empty. It was filled systematically by contracts whose terms were set by whoever had something to sell and whoever needed somewhere to put a man they had run out of other options for. The county jail was the base unit of American criminal custody for most of the 19th century. In rural counties across the South and the Midwest and the territories of the West, the jail was often a single-room structure of wood or rough-cut stone, built by county labor on courthouse grounds, maintained by the county sheriff out of a budget the county commissioners reviewed annually and trimmed wherever they could. The cells, where cells existed at all, were iron-framed and bolted to the floor. In smaller jurisdictions the arrangement was more informal still. A locked room, a cellar, a back section of the sheriff's own residence where the distinction between detention and domestic inconvenience was purely administrative. Federal prisoners were kept in these places. Men convicted of mail fraud, of counterfeiting, of crimes committed on federal territory or against federal officers, sat in county cells alongside men awaiting trial on local charges, men serving misdemeanor sentences, men whose debts had placed them before a justice of the peace. The federal government paid the county for the privilege. In Kentucky in 1871, the going rate was 35 cents per prisoner per day. In Illinois, it was 40 cents. In territories where county infrastructure barely existed, federal marshals negotiated rates on an individual basis, and those negotiations left almost no written record. The state penitentiaries that existed by mid-century offered a different category of arrangement. Ohio had opened its state penitentiary at Columbus in 1834. Pennsylvania had the Eastern State Penitentiary at Cherry Hill in Philadelphia, operational since 1829, a structure whose radiating cell blocks and enforced solitary confinement had been studied by reformers and penologists from across Europe. New York operated the Auburn system, which put its prisoners to congregate labor in enforced silence during the day and return them to individual cells at night. These were serious institutions with serious superintendents, and they were willing to house federal prisoners under contract because federal prisoners arrived with federal dollars. The contracts varied. Some were written by the state's attorney general and ratified by the state legislature. Some were memoranda signed by a federal marshal and a state warden with no higher authority involved on either side. The terms specified daily rates, obligations for medical care, provisions for labor, and conditions under which the federal government retained nominal jurisdiction over its prisoners. Whether those conditions were observed was a matter that no federal agency had the structure, the staff, or the mandate to verify. A federal prisoner transferred under one of these contracts disappeared, in the administrative sense from the federal record. His conviction existed in the court's docket, his sentence existed in the judgment, but where he went after sentencing, what institution held him, what work he performed, what happened to him if he fell ill or attempted escape or died before the term of his sentence expired, none of this was tracked by any federal office in any systematic way. The United States Marshal responsible for his transport filed a disbursement and closed the file. The state institution that received him opened a new register entry in its own ledger under its own numbering system governed by its own internal rules. 2 records, no connection between them. No mechanism by which anyone seeking to account for the man could move from one system to the other. This was not oversight. The structure was deliberate because the people who controlled the state institutions had no interest in federal scrutiny, and the federal officials who managed the contracts had no interest in what the scrutiny would have found. In the South, the arrangement took a form that the official historical record has only recently begun to examine directly. Following the end of the Civil War and the formal abolition of slavery, 11 former Confederate states enacted statutes that defined a broad range of behaviors as criminal offenses and imposed harsh sentences for their violation. Vagrancy, the failure to produce a labor contract, the act of leaving an employer's property without permission. The offenses were administrative constructions built to produce a specific outcome. A man convicted under these statutes was sentenced to labor, and that labor sentence was then leased by the state to a private operator. The state collected a fee, the operator collected the labor, the man served his sentence in conditions that the federal government, which had no prisons and no inspection apparatus, had no legal standing and no institutional mechanism to observe or to challenge. The first systematic attempt the federal government ever made to count its prisoners was not made by the federal government. It was made by the Bureau of the Census. In 1880, as part of the decennial enumeration, the Census Office assigned a special agent named Frederick Howard Wines to compile what became the first national survey of persons confined in American jails, penitentiaries, workhouses, and reform schools. Wines was a minister's son from Springfield, Illinois, a prison reformer by vocation and a statistician by necessity, and the report he produced, published in 1884 under the title Report on the Defective, Dependent and Delinquent Classes of the Population of the United States, is one of the most precise and most troubling documents in the history of American criminal administration. The numbers Wines assembled told a story the federal government had no institutional interest in acknowledging. Across the country, he found 58 state and territorial penitentiaries, 227 county jails with 50 or more inmates, and an uncounted number of smaller detention facilities whose keepers either declined to respond to his survey or had no records adequate to complete it. Of the federal prisoners housed in these institutions, he could produce only partial accounting. The marshal's offices submitted their disbursement figures. The state institutions submitted their own tallies. The 2 sets of numbers did not match. The discrepancy was not small. In some districts, Wines found that the number of federal prisoners the marshals claimed to be paying for exceeded the number the receiving institutions acknowledged holding. In others, the reverse was true. Men existed in the disbursement record who could not be located in any institutional register. Men existed in institutional registers who appeared in no federal court docket. The gap between what the federal government believed it was doing with its convicted prisoners and what was actually happening to those prisoners was, in Wines's careful language, a matter requiring systematic attention and legislative remedy. No legislative remedy followed for another 7 years. What Wines's report also documented, with the precision of a man who had traveled to every region of the country and examined the physical conditions of confinement himself, was the convict leasing system operating across the former Confederate states. He named the states. He noted the legislative authority under which the leases operated. He recorded the fees the states collected. He observed that the mortality rates among leased convicts in several states exceeded those of any other category of institutionalized population in the country. In Mississippi, the mortality rate among leased convicts in 1880 was reported at around 9% annually. In Arkansas, figures for certain labor camps ran higher, Wines recorded these numbers without editorial comment. The numbers were sufficient. The companies that held the leases appear in his appendices. Railroad construction firms, coal operators, turpentine distillers, levee contractors who needed labor to build and maintain the earthworks along the Mississippi and its tributaries. The names of the companies are verifiable. Their records, where they survive, are held in state archives and university collections across the South. Some of those company records were destroyed when the leasing system was formally abolished, state by state, between the 1890s and 1941, when Georgia became the last state to end the practice. Others were lost in the routine attrition of records kept by private firms that went bankrupt, merged with other enterprises, or ceased to exist without any formal winding down of their files. The federal government's own financial stake in this system has never been formally calculated. The per diem payments that federal marshals made to state institutions operating under convict lease arrangements mean that federal money drawn from the federal treasury passed through state accounts and into the operating budgets of systems whose labor conditions Wines himself had documented as lethal. That calculation could be made from the disbursement ledgers. The ledgers survive in federal archive repositories. No federal agency has made the calculation. The Three Prisons Act passed Congress on the 3rd of March, 1891. It authorized the construction of 3 federal penitentiaries, one at Leavenworth in Kansas, one at Atlanta in Georgia, and one at McNeil Island in the Washington Territory. The legislation was framed, in its congressional debate and in the newspapers that covered its passage, as a correction of a long-standing administrative deficiency. The language used in the Senate floor debate described the existing arrangement as makeshift, unsuitable, and a matter the federal government had neglected for too long. The word reform appeared in nearly every account. The word system, used to describe what was being replaced, did not appear at all. What was being replaced was not described. The contracts with state institutions were allowed to lapse as the new federal facilities were constructed and brought into operation over the following decade. The files documenting those contracts, held in the offices of individual federal marshals across the country, were not collected centrally. They were not archived. They were retained by the marshals' offices until those offices were reorganized, relocated, or ran out of storage space, at which point they were disposed of by whatever method was locally convenient. No directive was issued from Washington requiring their preservation. No archivist was assigned to collect them. This is the mechanism by which a record disappears without anyone being required to destroy it. You do not issue the order to burn the documents, you decline to issue the order to save them, and then you wait. The Federal Bureau of Prisons was established in 1930, nearly 40 years after the Three Prisons Act, by an act of Congress that placed administrative oversight of the 3 existing federal penitentiaries and a growing number of federal reformatories under a single director. The Bureau's own published histories begin with the Three Prisons Act as their point of origin. What preceded 1891 is characterized, where it is characterized at all, as an absence, a gap the Act corrected. The county jails and state penitentiaries that held federal prisoners for a century are described as temporary measures. The contracts that govern those arrangements are not described at all. Frederick Howard Wines's report, with its mortality tables and its company names and its columns of numbers that did not match, is not cited. The calculation he made possible has not been made. If this investigation has your attention, subscribe and turn on notifications. There is more to uncover. Your support makes it possible to bring these buried histories to the surface. The Eastern State Penitentiary in Philadelphia is a museum now. Visitors walk its central rotunda and look down the 7 radiating cell blocks that Charles Dickens described when he visited in 1842 as a place of such terrible silence that a man could lose himself in it by degrees without ever understanding what was happening to him. The cells are open. The iron doors stand wide. The paint on the vaulted ceilings has been allowed to fall in sheets, preserved in its state of ruin as a deliberate aesthetic, and the institution markets this carefully cultivated decay as an attraction. What the museum does not display in any of its permanent exhibits is a record of the federal prisoners who passed through those cells under contract with the United States Marshal's Office. Those records, if they were maintained at all, have not been located. Eastern State's own institutional archive, held at the Pennsylvania State Archives in Harrisburg, contains administrative records going back to 1829. The federal contract prisoners who are documented in the Marshal's disbursement ledgers as having been transferred to a Philadelphia facility during the relevant decades appear nowhere in Eastern State's intake registers under any designation that identifies them as federal rather than state inmates. They were received, they were housed, they were charged for. And somewhere between those three facts, their identity as federal prisoners was absorbed into the general population, and the distinction was not preserved. The record shows not destruction, but absorption. Those are different mechanisms with the same result. Frederick Howard Wines completed his 1880 survey, submitted his report, and waited for the legislative remedy he had called for. It did not come in the form he had anticipated. He continued his work with the National Prison Association, delivering papers at its annual congresses, compiling statistics, writing letters to senators and to the editors of law journals. He died in 1913, 22 years after the Three Prisons Act passed, having spent the better part of 4 decades attempting to make the federal government accountable for what it did with the people its courts convicted. The record he assembled survives. The accountability he sought has not been produced. The Ohio ledger that began this record is still in the District Court archive in Cincinnati. It is not catalogued in any digital finding aid accessible to the public. A researcher who knows to look for it can submit a records request and wait several weeks and receive, if the request is handled by someone familiar with that particular collection, a photocopy of its 40 pages. The contracts it references are not attached. They were never attached. The men whose per diem charges fill its columns have no corresponding record in any centralized federal repository. They exist in state archives, some of them in county courthouse basements and university special collections, and the administrative files of institutions that no longer exist except as historical subjects. Connecting them to the federal record that generated their custody would require years of work across dozens of repositories in a dozen states. No federal agency has commissioned that work. The Bureau of Prisons' official history runs to hundreds of pages. The period before 1891 occupies less than 2 of them. Leavenworth is still a federal penitentiary. The original structure, whose construction began in 1897 under the labor of the federal prisoners it was being built to house, still stands inside the perimeter of the current facility. The men who laid its foundations were the first federal prisoners the United States government ever officially claimed as its own responsibility. What their government had done with the men who preceded them, for a century before the first stone was laid, is recorded in scattered ledgers in archive boxes that have not been opened in decades, in mortality tables compiled by a statistician whose careful numbers no one was required to act on, and in the particular silence of an institutional history that begins its story precisely at the moment the previous story became too costly to continue telling. The ledger in Cincinnati is still there. The column marked disposition still reads, for a category of men whose names are otherwise complete, delivered to state authority. No further notation. The record ends where the accountability was supposed to begin. Thank you for staying with this until the end. If what you heard here stayed with you, the other films on your screen continue the investigation. Subscribe if you haven't, and I will see you in the next one.